AI and Data Show. For the latest updates in AI, with host Matthew Holman and special guest Anya Proops KC.
I'm here with Anya Proops. Anya, welcome to the AI and Data Show.
Hi, Matt. It's lovely to be here.
It is customary that every special guest is asked some embarrassing icebreaker questions.
Okay,
Can
not
I
too
ask
embarrassing.
you? Well, let's find out. If you could go anywhere in the world, where would it be?
I'd like to visit the top of a live volcano.
Wow.
Yeah.
Never heard that before.
Crazy, I know.
If you could have dinner with any celebrity, who would it be?
So I was thinking that I'd get down with the kids and say Molly May, but I actually don't know who she is. So I'm just going to say Muhammad Ali, because I think he'd be super interesting.
He would be very cool. What's your favourite music album of all time?
I'm going to say, and this obviously ages me, David Bowie's Hunky Dory.
Legendary. Do you prefer books or movies?
I love both, but I'm going to go for books.
Early bird or night owl?
Neither. But I got into the habit of getting up around 4:30 in the morning, which my husband's not very happy about.
I can imagine. Would you rather have pizza or pasta?
Spaghetti vongole with a nice glass of white wine, preferably in Italy in the sunshine.
Oh, sounds perfect. Do you say SAR or DSAR?
I'm afraid I'm old school and I say SAR,
Yeah.
but I know the kind of modern trend is DSARs. It's so wrong.
I've no idea how that came to be, but I agree with you. And we're going to put a poll to our viewers later, so we'll see what they say.
This is the important stuff.
On that important question.
Yeah.
It feels poetic to start at the beginning because the Ashley case, it doesn't just deal with subject access requests, it also tackles this question of what is personal data. Is the Ashley case creating something new in the definition of personal data, or is it really refining something old?
Okay, well, let's start by reminding ourselves of how the concept is defined in the legislation. So personal data means data that relates to an identifiable individual. And sounds like a really straightforward concept, doesn't it? But we know from experience it's actually really difficult to apply in practice, which is why it's a concept that's generated a lot of litigation both here and in the EU. The issue arose in Ashley because when we received the very limited data that we received from HMRC in response to the request, it was largely information that just referred to Mr. Ashley by name, expressly by name. And that was the only data that we got. And we said, hold on a second here. Our request relates to a processing operation that was fundamentally centrally concerned with Mike Ashley because it was concerned with a tax inquiry that HMRC had conducted into his personal tax liability that had resulted in HMRC imposing a tax levy of £13.6 million on Mr. Ashley, which was imposed on the basis, it was alleged, that he had sold certain properties that he personally owned to a company with which he was personally connected at an overvalue. And what we said is, this doesn't look right, because this is a processing operation that's fundamentally about Mr. Ashley and has very significant consequences for him personally. And it looks to us, therefore, that you have applied this personal data concept far too narrowly. And so that's how the personal data issue came into play in Ashley. And I mean, to answer your question, is this a new approach that we're seeing? Well, it is in the sense that the court concluded that the Court of Appeal judgment in Durant, which was decided under the predecessor legislation, the Data Protection Act 1998, where the Court of Appeal held in terms that it was a narrow concept, the court says that's not the right approach under the GDPR, that the concept is first of all wide, and second and crucially, it has to be applied in a purposive and context-dependent manner. What does that mean? What it means is that the more that the processing operation is focused on the individual and has implications for them personally, is impactful on their rights and interests, the wider, in effect, the concept applies. So, for example, in the Ashley case, some of the data that we were saying amounted to our personal data was data that comprised the valuation of the properties that Mr. Ashley had sold. HMRC said, that's not personal data, that's just commercial valuation data. You don't get that under a subject access request. And we said, no, because it's data that you've processed, part and parcel of determining our tax liability. So this is fundamentally a processing operation that's targeted at us, has very significant consequences for us. So that valuation data is our personal data.
It's about him.
It's about him, fundamentally. And the court agreed with us on that. So we see the court, this notion that the concept is wide, cashing out in very meaningful ways in that case.
Two parts to the definition of personal data. You have information identifying the individual, and you have that it relates to them. And it seems to be that relates to is the harder part. It's the bit that most organisations struggle with.
Yes, I mean, it depends. There can be some quite tricky issues around identifiability of the data. That's an issue that's been looked at in a number of cases, including one that went all the way to the House of Lords as it then was. So there can be issues about identifiability, but I'd agree with you that more often than not, it is this concept of relates to, which is quite an impressionistic concept. And how does that cash out in practice? And what we learn from the judgment in Ashley is that context is king when answering that question. To what extent is the individual the focus of the processing operation? To what extent is the processing operation impactful on their rights and interests?
Whenever corporates start dealing with SARs, they don't tend to do what we would do, I suppose, which is think about the detail behind the stuff. They'll go straight into process mode. It's find the data, process the SAR, conduct redactions, apply exemptions, get it out. And one of the things that Williams Justice seems to do in this case is take us back to the start of SARs and ask the question, well, what is the purpose of the SAR? Why does this even exist? In your words, what's the real purpose of the SAR?
Well, the statutory objective is to create transparency and ultimately accountability around the processing of our data by controllers. So the idea is that data processing is now so impactful on all aspects of our lives, and it's really important that data subjects are able to lift the lid on that processing and understand it, so they can understand what data of theirs is being processed, how it's being processed, how it's being shared. The idea being that that is necessary to empower the individual to safeguard their rights and interests in respect of their data processing activities that affect them. And one of the really important messages that emerges out of the Ashley case is there's this kind of assumption that the DSAR regime and the GDPR regime more generally is all just about protecting data privacy rights. So unless your privacy rights are kind of significantly engaged, the SAR regime doesn't really matter. And what the judgment shows in Ashley is that's not the right approach, and that you can legitimately use the subject access regime because that's important for protecting all of your rights and interests, including, for example, in the Ashley case, your fundamental right to peaceful enjoyment of your property, because they were trying to levy a significant amount of tax. So it's really important to understand that the objective is creating transparency, but so as to safeguard not just the data privacy interests of the data subject, but also their wider rights and interests insofar as they're engaged in respect to the relevant processing.
Fascinating. I'm going to resist strongly the urge to go off on a tangent with follow-up questions to that. And instead, let's cut to the chase. Most organisations loathe SARs. They're really hard work, and you have to search for data for what seems like forever.
Yeah, at great cost.
At great cost. When is a reasonable search not a reasonable search?
Yeah. Okay. So the legal test is that you don't have to leave every stone unturned. What you have to do to ensure is that you conduct reasonable searches in all the circumstances. But determining what is reasonable in any particular case, there aren't any blanket rules that you can apply. And everything turns on the particular circumstances of the case that you're dealing with. So what may be reasonable in one case is not enough in another case. And issues to consider here are, what's the significance of the data in issue and the underlying data processing operation? How difficult is it to find the data that you've been asked to find? Is it difficult to find the data because actually you've organised your systems in quite a disorderly manner, which is then obstructive to enabling you to find the data in question? That's obviously a point that can count against you when deciding reasonableness. But I think the practical advice that I tend to give to clients in this area is generally you have to work pretty hard to show you've crossed that line of conducting reasonable searches. And I sort of come back to this point that what's really important for controllers to think about is they want to present as the good guys, as the people who are really trying to get to the right answer here, to assist the data subject in accessing the data that's important for them to see, and that you therefore do have to work pretty hard and show real willing when it comes to the issue of searches. And if you do that, then the court and the ICO is likely to have real sympathy for you and is unlikely to order you to conduct further searches, the more, you kind of try to limit the exercise, and particularly if you do it in a self-serving manner, which is what we saw HMRC doing in the Ashley case, the greater difficulties you're going to get into.
As an aside, can I ask you a question about things that I know all of our organisations struggle with, which is what about WhatsApp? What about TikTok? What about Twitter? What about? The extent of what you might have to search feels insurmountable.
Yeah. I mean, I have enormous sympathy for organisations having to deal with these requests. And again, do you have to search WhatsApp messages? It depends. Do you authorise the use of WhatsApp as a communications tool as part of your business? If you do, then yes, you probably do have to search WhatsApp messages. If you don't, you can get in some quite tricky issues around the extent to which you need to search relevant WhatsApp messages. So that, again, there's no blanket rule that you can apply, and every case is going to turn on its own particular facts. What
about the exemptions? We know there are lots of them. They hang out in the schedules for the DPA. They often feel vague and they often feel imprecise. They can be hard to apply. What 2 or 3 tips would you give to any organisation that was trying to rely on the DPA schedule exemptions?
Okay, so the biggest mistakes that I see being made are, first of all, in the application of the mixed data exemption. This is the exemption that can potentially apply where the data of the applicant, the data subject, is inextricably mixed together with the data of a third-party individual, which you might have, for example, if you've got an email where manager A is expressing an opinion about the data subject who's an employee. That data is the combined data of both the manager and the data subject, and the question is what you do with that data, and that's the issue that the mixed data exemption is designed to address. What I very often see is controllers saying, oh, well, that data includes the data of a third party, so you're not getting it. That is not the legal test. The mere fact that the data is mixed together with the data of a third party does not mean it's exempt. What you have to do in that scenario effectively is balance the competing interests in play. The data subject's fundamental interest in achieving subject access in respect of their data, which is an important gateway to them being able to enforce their other rights under the GDPR, balanced against the potential privacy invasion for the third-party individual that would flow from the disclosure. Sometimes that privacy invasion will be negligible or won't be sufficient to outweigh the data subject's interest in accessing the data. And that's where the balance lies, you have to disclose it. It isn't exempt. So, this notion that, you can't apply blanket rules, you're going to have to look at each case on its own individual facts and the context and circumstances of that particular mixed data, its nature and the wider circumstances in which it was created. So that's the first point on exemptions. The second point on exemptions, and it's something that again comes out of the Ashley judgment, is where you're relying on a prejudice-based exemption. For example, if we disclose this data, it will have a prejudicial effect on criminal law enforcement. Bare assertions are going to get you nowhere. So in the Ashley case, HMRC basically sought to withhold certain data on the basis of a bare assertion that its disclosure would compromise its ability to recover tax. And we said, why?
And didn't they say something like, oh, it will give clues as to how we investigate tax in the future or something like that?
Yeah, and that's hopeless, right? Because what's very clear from the jurisprudence, not least from the Ashley case and an earlier case I was involved in called Saw Lynn, is that, first of all, the controller bears the burden of proving that the exemption is engaged. Second, that burden is likely to be very heavy where you're relying on a prejudice-based exemption. And what you have to be able to adduce is cogent and compelling evidence that disclosure of the data would in fact have, or at least would be likely to have, the requisite prejudicial effect. And as I say, bare assertions, absolutely hopeless. And that's all HMRC had. They didn't even adduce any evidence in support of their case that it would have the relevant prejudicial effect. So the court had no difficulty dismissing their case on the exemption. And so we got the data in issue.
What about redactions? So most organisations, when they're dealing with a SAR, they will redact. I don't think I've ever seen a SAR that didn't contain some kind of redaction. Yeah. Could I just redact everything if I'm disclosing a SAR for you, for example, except your name and initials, or do I have to be giving more than that?
So obviously we start from the point that the right of access is intended fundamentally to give the individual a right of access to their own personal data. So you sort of start from the premise, well, surely that means they don't get everything else that might be contained, all the other information that's contained in the document within which their personal data sits. But the reality is that where disclosure of the personal data in a decontextualized form would be unintelligible to the recipient data subject, in general, you will be subject to a duty to provide the contextual information so as to render the data intelligible to the data subject. So it's not good enough just to extract the name and say, well, there is a document with your name in it and there's the name, because that's totally meaningless to the data subject. Yep. In those circumstances, you're generally going to be subject to an obligation to disclose the wider contextual information and potentially the whole document, depending on the circumstances. But it's only a general obligation in the sense that you may be able to lawfully withhold that contextual information, even if it may render the data unintelligible in the hands of the data subject, where the disclosure of the contextual information would effectively breach third-party rights and interests. So in the relevant CJU judgment on this, they talk about, and actually could potentially be the interests and rights of the controller themselves, they talk about the protection of trade secrets, copyright, wider intellectual property considerations, and those sort of circumstances. Depending on the circumstances, you may be able to justify withholding the contextual information effectively to safeguard those competing rights.
Finally, last question. What top tips would you give to organisations out there who are listening and watching about how to comply with a SAR? What in your mind is the best way that an organisation could go about dealing with what is otherwise a fairly painful exercise? Well,
if we take the HMRC case as the kind of moral lesson on this issue,
exemplar, if not.
Training, because it was very clear that the people dealing with Mr. Ashley Sarr did not understand the underlying principles or how they should be applied, which is why they went wrong so many times in so many ways. And the reality is educated organisations are already pretty far down the road in terms of safeguarding themselves against litigation and regulatory risk. So that's a really important consideration. Obviously, some of these cases can be really difficult, and if it's a case where you think the individual may be litigious or may be ready to run off to the ICO, always important to think about getting advice, obviously. This point that I made earlier about making sure you have effective triage systems in place so that those requests, when they come in, are going to the right people at the earliest possible stage and not just sitting in someone's inbox because they don't really know what a SAR is. So that's obviously super important. And I think the final kind of top tip is this point that you've got to be really careful about applying blanket rules. I know from a corporate perspective, it's a way of saving costs and dealing with things efficiently. But this is an area where the more you apply blanket rules, the greater the litigation risk and regulatory risk you're going to be generating for yourselves.
The more likely you are to come undone.
Exactly.
Which is counterintuitive, really, isn't it? The idea of having those rules and procedures in place is to try and streamline and reduce risk through governance. But actually, the more you apply blanket rules, the more likely you are to be in trouble.
Yeah, I mean, one of the problems with this regime is, this need to apply a very context-driven, every case has to be decided on its own particular factual basis. That imposes such enormous costs on businesses, it does start to feel very disproportionate. But the trouble is, how do you arrive at a result where you can just say, well, because this is all really expensive and onerous and we get so many of these requests, it's killing us as a business. Does that cash out and you being able to say, well, I'm just going to apply blanket rules because it all gets too expensive otherwise? Well, the reality is, unfortunately, that at the moment, the legislation doesn't allow for that.
Anya, thank you very much for your time. Before we go, do you want to let the viewers know about the 11KBW conference?
Oh yes, we've got our annual Information Law Conference, which is running on the 13th of March. It's an all-day conference, really interesting topics. We're going to be talking about data litigation and regulation, but also online safety and AI regulation. So it should be an interesting day.
Anya Proops KC, thank you very much for your time.
Thank you so much.